Good morning. I'm Caitlin Chin, and I'd like to welcome everybody to our discussion. As the name of our event may suggest, we convene today at a unique time in both EU and U.S. competition policy. This panel aims to explore the central question of how legislation, including the Digital Markets Act, American Innovation and Choice Online Act, and others, can promote competition in digital marketplaces, while also navigating other interests in privacy, security, content moderation, and innovation. And to help unpack these issues, we've invited 4 experts with perspectives from both the U.S. and EU. Joining us from Brussels, Anna Malheiro is a professional staff member with the European Parliament's Internal Market Committee. Anna has been directly involved with the drafting of the Digital Markets Act and brings a close perspective on the competition and data governance framework of the bill. Next, Krisztian Katona is Vice President of Global Competition and Regulatory Policy at CCIA and a former International Antitrust Counsel at the FTC. In his role, Krisztian works with a wide range of CCIA member companies that include Amazon, Facebook, Apple, and Google, and offers insights on the potential legal implications for industry, as well as multilateral competition issues. Charlotte Slaiman is the Competition Policy Director at Public Knowledge and a former FTC antitrust enforcer. Public Knowledge is one of over 50 organizations that has signed a letter in favor of the House Judiciary Committee package last September, and is also a leading advocate for the self-preferencing and App Store bills in the Senate. And finally, we have Bill Baer joining us from Brookings. Bill has the unique vantage point of somebody who has led U.S. antitrust enforcement at both the DOJ and FTC, and earlier this year published a set of principles that ultimately argued that legislators do not face a binary choice between competition and security. And this is a topic that we'll explore more today. Just one housekeeping item, we will leave about 10 minutes at the end for audience questions. So please go ahead and submit yours through the CSIS event page. Now, I'd like to start off by asking Bill to set the scene for us. Under existing competition laws, both U.S. and EU enforcers have initiated antitrust investigations or brought complaints against big tech companies like Google, Apple, Amazon, and Meta in recent years. So could you describe the challenges that these actions aim to resolve? In other words, why are enforcers specifically directing attention to large digital platforms?
Thanks, Caitlin, and it's a privilege to be on this panel. It's a privilege to be working with you again. Your audience may not know that you and I worked closely together for 2 years at Brookings, and we were sorry to lose you, but we lost you to a great organization, so we wish you all the best. But these actions or concerns with the power of the tech platforms are not limited to the US or Europe. You see it in Asia, all around the world. What are the concerns? Well, these companies have unique power, monopoly power, of a fashion that we've not seen before. Why is that? Well, there are certain phenomena associated with the development of these platforms that potentially gives them the power. First of all, they benefit from network effects. A platform like Facebook becomes more valuable the more people that use it. As the market tips in favor of that form of platform communication, it's very hard for other competitors to come in and challenge. That then gives a platform the ability to limit competitors. In the case of Facebook, they have been found to gobble up anybody who might be a competitor in the future. So both using the competition laws in Europe and the US, there have been challenges, successful challenges by Europe, pending challenges here in the US against Facebook and against Google, others rumored to be in the way to sort of address the unique ability of these platforms to be persistently dominant and to impose costs on consumers, on competitors, on people who use those platforms to communicate to us as consumers. It involves a somewhat different mode of antitrust analysis, competition analysis than we're used to, because we as consumers don't, for the most part, pay for access to the platform. We pay by sharing our data, sometimes unknowingly, unwittingly, and that enables the platform as well to have considerable power about what it does with that information. It can use that information to self-preference its own products. It can sell that information to advertisers and sellers who want to communicate or sell to us through the platform. And with antitrust, we always traditionally look for an effect on price competition, increased prices to us as consumers. That's not how these platforms work. It's why it makes them a little different, a little harder to analyze. And it's why there is concern both being seen through court actions and in legislation in Europe and the United States.
Thanks, Bill. And after 2 years of working together, I can say that I'm very excited to share the virtual stage with you. So what I'm hearing is that this combination of network effects and acquisitions have created unique concerns about a tipping effect in digital markets, and that enforcers all around the world have taken notice. However, there is a growing consensus in both the EU and the US that existing competition laws might not be enough. So Charlotte, could you talk about the bills currently pending in the US Congress to create new rules for dominant digital platforms? How might they change existing US antitrust enforcement?
Great. Thank you so much, Caitlin, for having us today. I'm really excited to talk with you all about this. So we have definitely found that existing antitrust law is not going to be enough to rein in the power of the largest tech platforms. Some of the reasons are the ones that Bill was already exploring. Another is that antitrust cases take a long time. These markets move very quickly, and if you are a small competitor waiting for the antitrust case to come through, you're going to go out of business while you're waiting. And there are additional special economic characteristics of these platforms. Since we have such a limited time, I know that Bill wasn't able to get into all of them, but I think another important one is a characteristic of the digital environment where companies can really have a much greater influence on the decisions that users are making because they're controlling that graphic user interface. So these are all some of the reasons what Bill was talking about, what I've been talking about, that a package of bills was introduced on the House side in 2021. In 2019, they started their investigation that went on for and trying to identify the solution. So there was a package of 6 bills introduced on the House side with a variety of different tools. The one that seems to really have the momentum right now is non-discrimination, but that is just one of the tools that we were really excited about. So the non-discrimination bill, the American Innovation and Choice Online Act, that's from David Cicilline and Ken Buck in the House and Amy Klobuchar and Chuck Grassley in the Senate, although there's now a long list of co-sponsors both in the House and the Senate, is focused on this problem of anti-competitive discrimination by the largest platforms. These companies are so vertically integrated that they often own a company that is competing on their own platforms. So we believe that creates a real conflict of interest. They have the incentive and the ability to preference their own products and make it much more difficult for a smaller competitor to get a fair shot at winning customers. So we really need to open up those markets for competition, creating fair competition on the platforms. The other major goal of this legislation is to create fair competition against the platforms. Because of that key role that the platforms play, that they are a major way for other companies to access consumers. We call this gatekeeper power. It's one of the things that was analyzed in the investigation that the House committee did. Because of that gatekeeper power, they control not just competition against smaller companies that they own. So this is, as an example, you've got Google Search is like the large platform, and then maybe Google Maps or Google Reviews is the business user that they also own. So they're controlling not just competition against Google Maps, but actually also potential competition against Google Search. So another important goal of the bill, I think, is this broader non-discrimination, not just self-preferencing, but also making sure that we're protecting potential competition against the platforms at the platform level. Caitlin, you'll let me know when I'm out of time, but I can briefly talk about the Open App Markets Act as well, which is another important piece of legislation that has a lot of momentum right now that I think we may actually see, as well as the Innovation and Choice Online Act getting a vote in Congress. The Open App Markets Act is, zooming in on app markets, which is a really important sector of our economy, and imposing similar fair competition rules there to make sure that smaller app developers can have a fair shot, making sure they can communicate with their customers, they have access to key phone features, and that there's competition in payment processing, which is one of the big difficulties that we're seeing for competition today.
Thank you so much, Charlotte. And I know I look forward to diving into some of the provisions that you've discussed. But first, I want to pivot to the EU, because the European Parliament and Council announced a provisional agreement on the Digital Markets Act back in March. So turning to Anna, what are some notable provisions in the Digital Markets Act, and what are the implications for both gatekeepers and small businesses within the EU?
Many thanks, Kathleen, also for the opportunity to speak here. I should, of course, add the disclaimer that I do not, so that any views are my own, and in no way I should the Parliament be bound by my whatever I say. Having said this, the first thing I would like to say is that the Digital Markets Act is just about to be adopted. It will be formally adopted next week by the Parliament. After that, the Council, a couple of weeks, and then it will be formally published in the official journal, which means it becomes law, binding law. Probably in October we expect. After that, there are 6 months for companies to adapt. Then a dialogue between the Commission, the European Commission, who will be the enforcer of the DMA, will start. It's very short, it's around 2 months, and after that, companies have 6 months to comply. After 6 months, they have to comply. So there is again a 6 months period for adaptation. So in terms of what is important, and perhaps a bit too specific to the European Union, is the fact that this is not a competition law instrument, and I think in this panel is maybe important to clarify this. The concerns are very much coming from competition law, from some the empirical evidence comes from complaints and many antitrust cases, some frustration as well, as it has been Bill has mentioned that antitrust is often not quick enough to tackle the issues. But it is, so the primary aim is to harmonize rules across the European Union, the several member states, and the aim is to promote contestability and fairness across digital markets. So having said this, how does it work? And the another important thing is that antitrust remains complementary, and this was an explicit choice of the legislator. So wherever the DMA, whatever that is not covered by the DMA will be covered by competition law, and competition law remains completely unchanged by this. Then in terms of the design of the DMA, what will it change? There are two concepts: the gatekeeper concept, which I understand from Charlotte is also being discussed. I think the concerns are very similar. We have the concept, so basically a company, there is a definition of what a gatekeeper is. A gatekeeper is a company who is important for the internal market. It operates an important gateway and then enjoys this position for quite some time. If I may simplify, this is more or less, this then translates into quantitative thresholds that allow the legislator to make presumptions, which is of course important also for legal certainty and for the administrability of the law. So basically, the thresholds we have to measure the significant impact in the internal market are turnover and market capitalizations, the same used in your bills. But the market capitalization figures are substantially lower in the European Union. For us, it's 75 billion. Whereas I understand you are at quite 600 billion, something like that, I understand. We also have, then we also have turnover, and the fact that the companies need to to provide services in 3 member states. So in addition to that, another key concept I think that is also different from the bills that are being proposed is that this act applies to companies that operate what important gateways. And these important gateways are defined in law. They are 10 that go from online intermediation services, social media, and so on. I'm not going to, because we don't have much time, but they are closed, let's say, services. So the law applies only to these. Another important aspect is that because it is like that, so the Commission is not expected to make or to engage in any market definition exercise or qualification of dominance or even efficiencies defenses. So this was the explicit choice of the legislator, because indeed the idea is to move away and not to, I think the concept of dominance was understood, but there are a number of studies that show that there is no point in showing that these companies have dominance, because it's a different concept of market power, if you wish. So in a nutshell, and then in terms of prohibitions and obligations, also important. I think from what I understood from the bills that are being discussed now in the Congress, there is a number of, there's a lot of convergence. In the DMA, you have prohibitions and obligations. A number of data combination is prohibited, for instance. So the aim is to avoid conflicts of interest on some cases, to promote access to data, promote multi-homing, promote consumer choice, promote transparency and fairness. So, and this translates into a number of obligations. These all obligations are directly applicable. Some of them may require a specification decision by the Commission, and this is so because it was understood that in some instances it's important to enter into a dialogue with the companies to specify how should these obligations be translated in practice. But they are all directly applicable, but with this important nuance, which I think it will be important for companies and for the Commission as well.
Thank you so much, Anna. We're glad to have you here, and I think that all of us antitrust nerds will be closely paying attention to the final implementation and future enforcement of the Act. But now some companies have cautioned, though, that legislation in both the U.S. and the EU could come with unintended economic consequences. For example, CCIA recently sponsored an economic study that found that bills like the American Innovation and Choice Online Act could decrease market share or hurt investment. So turning to Krisztian, could you perhaps explain some of the concerns that are coming from industry? For example, what provisions of legislation might pose challenges to the economy or to innovation?
Thank you for that question, Krisztian. And I also like to thank CSIS for the invitation. It's really a pleasure to join this panel today. So turning to the economic analysis by NERA that you referred to, these studies really have estimated the quantitative costs of AICOA, kind of one of the bills that Charlotte has already discussed. And we really focused on kind of like when it comes to the quantitative costs of covered firms, you know, like basically consumers and investors, what would be the cost in that regard? And the NERA study really found that AICOA would increase operating costs for covered firms significantly by really forcing firms to structurally separate, either by spinning off or discontinuing many existing services, or also by operating those services independently from their current platforms or ecosystems. And in that regard, NERA found that the present value of the estimated increase in operating costs for just the 5 US firms that would be covered upon enactment of this bill, you know, AICOA, is up to approximately $319 billion. And the study concludes that these costs would ultimately be passed on to consumers. And the proposed bills in that regard would cause economy-wide harm well beyond just technology companies. So one key question, I think, with the proposal and all of the proposals internationally is who would be covered under it? And the antitrust bills are messaged in the US as just targeting particular technology companies. But the NERA study really reveals that based on the market capitalization language in the bill, more American companies would be captured in just a few years. I think it's about 13 additional companies in the next 5 to 10 years, and likely over 100 companies by the late 2030s. So regarding the findings, the NERA study really concluded that AICOA would force covered companies, for example, Amazon, to divest, eliminate, or really reduce the cost of currently integrated services. And one example is Amazon Prime. NERA, as part of the study, really measured the bill's effects of higher retail prices and the loss of services currently included in those integrated services. And in that regard, Amazon Prime, what would need to be separated? And it found a consumer value loss of approximately $22 billion per year for Prime members, which is really a harm of about $148, almost $150 per Amazon Prime subscriber per year. But similarly, large consumer welfare impacts will be likely to harm users of each of the other targeted services, and also users of other services that become regulated later on. So Caitlin, you also asked about the bill's impacts to investors. And in that regard, NERA found that increased operating costs reduce the net present value of cash flows from firms to their investors. And policies like AICOA that really would increase operating costs can be assumed to reduce the market value of their stock, harming their shareholders. And the study found that, I don't want to go into a lot of numbers, but by the late 2030s, increased operating costs for covered companies would reduce their market value significantly, causing up to about $109 billion in losses to public sector pension plans and over $1 trillion to investors in S&P 500 index funds and large cap firms by the late 2030s. And public sector pension plans would be particularly adversely impacted. And why is that? Because on average, what we've seen is approximately 86% of state and local government employee pension plans have the 5 covered US firms in their top 10 holdings. So this would include, like pension plans for teachers, nurses, firefighters, police officers, and other state and local government employees. NERA, based on this, estimated that the immediate impacts to plan members would average approximately $252 per plan member upon enactment of AICOA. And the average losses total almost $4,000, approximately, I think, $3,928 per plan member by the late 2030s. So one important thing I would just close my initial remarks with is really the importance of looking into the costs of these proposals. We sponsored this study by NERA because there was simply nothing out there about the expenses and the cost-benefit analysis of these sweeping proposals. It seems that no one really seems to have quantified the costs and benefits, for example, of AICOA, including the bill sponsors and supporters of the bill. And we thought it's very important to get a clear picture of what this bill would cost to consumers and the economy. And based on this, I think it's very important, as we're looking into antitrust reform in the US, Europe, and in other jurisdictions as well, to really give careful consideration of these proposals' long-term impact and what they would cost, but also what could be their unintended consequences. Thanks, and back to you, Caitlin.
Caitlin, if I could I just want to make 2 quick points.
Go ahead.
Krisztian, I really think you're factually wrong here. The NERA study was not just about AICO. It was about AICO. It was about the entire package. And that's why you're saying things like spinning off companies. That's not in AICO. That's in the old package. This is only one bill from that package of 6 bills that we're advocating for today. I would love to talk to you about the Ending Platform Monopolies Act, which is, I think, what you're talking about. The NERA study, I have reviewed it. It was about the package of bills. And so all of those numbers that you're throwing out are about that package of bills. We are just talking about one bill, the American Innovation and Choice Online Act. So you cannot attribute the findings of that study to this one bill.
I started with AICO related bills, but I didn't want to go into all the details. We don't have too much time on that, but correct.
I think that's an important detail.
Bills. Yeah.
Can I pile on here? I respect NERA and CCIA. I think looking at these 2 studies, they do everything they can to assume the worst that is coming out of the legislation. Forced divestiture, which, as Charlotte just says, isn't in the bill that we're talking about. The elimination of Amazon Prime. It's not at all clear that would be a required result of this. one of the things that people who haven't studied the bill don't appreciate is that there are 10 specific behaviors that are prohibited, but the government, and only the government, not a private attorney, has to go to court and show not only that the conduct was engaged in, but that had a material adverse impact on competition. And so there is going to be careful, deliberate study by the law enforcers before they risk going to court. And then there's going to be a neutral judge who's not only going to determine whether or not the behavior occurred, but the parties will have the full opportunity to come and explain why there was no material impact on competition, and to the extent they can show it, that whatever efficiencies or cost savings come out of this behavior far exceed any potential adverse impact on competition. One more final point. The notion that investors are going to lose all this money 20 years from now in the late 2030s is really kind of a made-up fact. The advisors to pension funds, if tech platforms are losing some of their value, they're not going to just ride it out and take these losses. They're going to move their money to other companies that are more successful. One of the things this bill does is create potential for greater rivalry for these platforms. And so this, trillions of dollars of lost wealth going to an average teacher or first responder or nurse, it is really, the technical legal term I think is bullshit. And it doesn't do CCIA and its members any good to come up with these draconian predictions that are so easily punctured like a pin in a balloon.
Can I reflect on that, Caitlin? Just,
Sure. How about we give you maybe 10 to 15 seconds to respond, and then we can move on.
Sure. Just like starting with kind of like Amazon Prime Bill. I think Amazon Prime is really a perfect example of a service that would have to separate due to AICO and due to the disruption of its integrated nature. When it comes to Amazon Prime, it's a subscription service that really offers subscribers a range of services, including the free two-day shipping of many products in the Amazon marketplace and various other online services, including Prime Video. On the marketplace, and just very briefly, I will limit the discussion to the marketplace and will limit possible delivery speeds to 2-day and standard. But on the marketplace point, not all products are included in free 2-day shipping with Prime. On that, to let shoppers know which products are included, they have a special symbol next to the products. We know how that works. Users can filter their searches to only see the products with Prime shipping. And this is really essential to make Prime useful for shoppers, because shoppers don't want to have click on dozens of products searching for one that has delivery in, free delivery in 2 days. But on the producer side, Amazon can only offer 2-day delivery if the seller meets certain specifications. And for simplicity, that includes, the minimum requirement is that the seller stores its products in an Amazon warehouse on Amazon's logistics network. And as storing these products is costly, Amazon charges the sellers compensation for this service. Now, AICOA prohibits several elements of the Prime service on the marketplace. If Amazon can't receive compensation from sellers for storing their goods, then it will not store their goods, and because of that, it won't be able to offer standardized rapid delivery. But if Amazon can't show clearly to shoppers which sellers are participating in free delivery with Prime, Prime becomes much less useful to subscribers on the marketplace, and Prime on the marketplace, because of that, breaks down. But also, as the potential fines are enormous, I think it also becomes very difficult to justify keeping other services like Prime Video and the Prime Bundle under AICOA. And in that regard, AICOA really would punish essential features of product integration. So Prime Video, for example, would have to operate it as if it were an independent service, distinct from the marketplace, even if it were included in the bundle. And I think this really eliminates most potential synergy and cost savings from product integration, but also, importantly, most user experience benefits as well. I think we could go on further on this, but I just want to make sure we cover other points as part of the discussion as well. I just wanted to respond to Bill on that point as well. Thank you, Caitlin.
Thank you. And I hope to continue this conversation further, but right now I want to shift into another debate that I've been following, which is over content moderation. In the past few weeks alone, several individuals, which range from a group of technology law professors to 4 Senate Democrats, have documented some concerns that the American Innovation and Choice Online Act could impose liability on covered platforms for removing harmful content. And as one example, Parler has been cited, which is a social media platform known to host extremist content, and which has also recently sued AWS for terminating its service, in part arguing that AWS didn't ban Twitter for hosting violent content. Even though Parler lost its case, I do first want to start by asking the panel if platform non-discrimination in the US bills could open the door for example, a conservative state attorney general to sue in the future, or otherwise discourage large platforms from removing harmful content. And first, perhaps we could first start by talking about the US legislation and then move to the EU after that.
Sure, why don't I start and just briefly say, I think the concerns, while well-intentioned, are not material to what's in this bill. By that I mean is, if you have a platform that has rules of the road that are generally applicable to anybody, and some content provider breaks the rules, then you can take sanctions against them. That's not discriminatory behavior. It is, in fact, insisting that everybody abide by the same rules. So I don't think at the end of the day there is going to be any change in the ability of a platform to engage in content moderation. Moreover, if you had a state attorney general who wanted to claim there was this discriminatory approach, he would, first of all, have to show that it was more than simple application of generally applicable rules, but also would have to show that that the content moderation being engaged in is creating a material harm to competition. And so it strikes me, again, you have to go before a court and prove a case. We saw that the false claims of election fraud didn't fare very well in our district courts when some folks sought to sue over them a year and a half ago. So I don't think there is a lot to worry about there. Obviously, we are concerned about preserving the ability of platforms to engage in content moderation. I don't see anything in this bill that puts that at risk.
Kevin, can I?
Does anybody else? Oh, go ahead.
Sure. Yeah, on content moderation, we see really that a number, like on focusing on AICOA, for example, we see that a number of senators and also a growing number of experts have repeatedly raised the very serious issues and concerns with the bill. You mentioned the kind of like letter from the 4 Democratic senators that really, I think, speaks for itself. I'm not presuming to explain their arguments, but regarding whether an abusive user or content provider being moderated by a regulated platform would constitute material harm to competition, to that core question, we can be certain because these terms simply haven't been defined. Bill talked about, material harm to competition, but we have over 130 years of U.S. antitrust jurisprudence in which material harm to competition actually hasn't been used as a term, but AICOA creates this term without actually even defining it. But first of all, one concern is that we know that business is subjected to content moderation, and they didn't have already framed their grievances as harms to competition. And you mentioned the Parler example, Parler briefly sued Amazon's AWS with far-fetched antitrust claims. So it isn't like it's theoretical, it has happened. And what prevents these suits from succeeding is our, existing antitrust law system. But in addition, some co-sponsors of the bill think that the bill would do exactly that. And we shouldn't discount their interpretation of the bill they're actually sponsoring. So I guess in that regard, how to address these concerns, I would suggest that we say, don't start from the premise that it's a good idea to come up with gerrymander rules around a specific group of companies, because what we have seen that works, if it's right rules, of general applicability that really apply horizontally across the economy, the way we usually do in antitrust laws versus targeting particular segments of the market and particular companies. But also, given the recent litigation position and you asked about is the public pronouncements from the state attorneys general in Florida and Texas, it is quite easy to imagine how an AG in either of those states might want to use the AICOA's provision to force those app stores to distribute this content. I think, like we had to litigate those cases, and our successful litigation in Texas and Florida demonstrates that there's, in that regard, little role for government in deciding what shows up in one's feed and what apps are on one's device. But I think it's a very, very extremely important concern that like within AICOA as well, it's not a surprise that regularly, senators and commentators have weighed on this. And I think I see it as a very, very serious concern.
So maybe, sorry.
Go ahead, Charlotte. I'll weigh in after you. Go ahead.
That's kind of you. Just to add that we discussed also this issue. We are also about to pass a law, the Digital Service Act, which is seen as the sister piece of legislation of the DMA. And the DSA will be also adopted next week. And it primarily tackles the issue of handling illegal content, products and services entering into the European Union. Via online marketplaces, and how companies should go about this. But at the same time, it also dealt with harmful content, and in particular the issue of disinformation, how companies should handle disinformation. Of course, the basic principle, our equivalent to your Section 230 is the e-commerce directive, which has been in force for already 20 years, and the principle of the liability exemptions of intermediaries remains. So this was an important point of the discussion. On the issue of the potential conflicts between a ban on self-preferencing and the obligations of companies to remove content, this was discussed, and basically the outcome is that so basically companies cannot say that they do not comply with their content moderation obligations because of any ban on self-preferencing. I suppose this will be left to case-by-case assessment by the Commission, who applies both pieces of legislation. But the companies, the issue of freedom of speech, of course, was discussed ad nauseum, and it was a very important discussion in the Parliament. What we have now is that companies, so they are not liable, this does not change, but they have an obligation to assess the risks of disseminating harmful content, and then to mitigate the risk of over moderation. There is a transparency obligation for companies that they have to explain or to detail in the terms and conditions of their services what type of content do they moderate, and then end users should also know what type of redress options do they have in case they feel that content should not be put down. So this is a bit the input from Brussels. We are very quick at passing laws, as you see, but I'm not sure if the outcome. I hope it will be successful. But this is happy to discuss in more detail if you wish on another occasion.
So
thanks, Anna. Maybe we could.
Oh, Caitlin, I'd like to respond as well.
Sorry, go ahead.
I think it might be helpful to zoom out on this problem. We're getting really into the weeds about there's no private right of action, so Parler can't bring a case. Okay, but maybe you can, anyway, it just gets really, we're like gaming out exactly how each lawsuit is going to go. And folks are doing a lot of important work on that, including at Public Knowledge, trying to think about what kind of edge cases might come up. But fundamentally, this is a really important clause for competition, because this protects a small company that is a potential competitor against one of these large platforms. We really are not being well served by the status quo here, where those small companies cannot get a fair shot. And that's what this clause is about. And through that competition, I am actually hopeful that we are able to put more pressure on these companies to do a better job of content moderation. Public Knowledge supported the Stop Hate for Profit boycott against Facebook that many advertisers were engaging in because of the election-related misinformation that they were leaving up on their platforms. I think we would all be better off if Facebook had done a better job and would do a better job in the future of taking down that really harmful content. But I think the way to achieve that is through users having the power to leave and choose an alternative network if we're not happy with the content moderation that we're being faced with on these options right now. And today we are locked into one or a couple platforms. This bill would give that competition a chance so that we could have other choices. And I think that's going to be one of the best solutions to address the content moderation concerns that folks have.
I think that's a really interesting point. You mentioned the Stop Hate for Profit boycott, which effectively, as I understand it, called for Facebook advertisers to stop advertising during the month of July 2020 to put economic or public pressure on Facebook. But maybe as a follow-up question, you mentioned the role of consumer choice, people having the power to leave a platform that they don't like or a platform that doesn't effectively moderate content. But are there limits of traditional antitrust mechanisms or traditional consumer choice mechanisms to improve content moderation?
Yes. Yes. And I think about how antitrust intersects with a variety of issues. Content moderation is one of them. Privacy is another. And I think there, in both cases, is a lot that competition can do, but that is not going to be the only solution. So one of the bigger, future policy goals that Public Knowledge has is to have a new digital regulator that can really comprehensively address these complicated questions that are always intersecting. I don't think that competition is going to be enough, but I think it'll be a really powerful tool for users.
And then perhaps I have another follow-up question for Bill or Charlotte or anybody else who wants to jump in. I was just curious about your take on some of the proposed amendments to Senator Klobuchar's bill. For example, to add clarifying language to confirm that the bill doesn't change liability for a covered platform for moderating content, or perhaps to add content moderation to one of the affirmative defenses by saying that companies are still allowed to protect safety, their privacy, moderate content. So what is your take? What might some of the implications be?
So I think the legislation...
Go ahead, Charlotte, you go ahead.
Is drawing the line in the right place. And my concern about that amendment that was proposed is by putting the words content moderation into the legislation, if we were to adopt that amendment, I really think we're opening a Pandora's box. I think that is going to make it much more difficult for courts to work through this. The way that the legislation right now is designed is you have to show that this is conduct in a manner that would materially harm competition. And I want courts to be asking that question, does this materially harm competition? Not what is content moderation? Is this an example of content moderation? That feels like a really messy place for courts to be trying to decide. So I'd rather keep the words content moderation out of the legislation.
Well put.
And then perhaps I have another question for Krisztian. So the Digital Markets Act, unlike the American Innovation and Choice Online, doesn't include this phrase that we've been hearing a lot, material harm to competition. But like Anna described, we do have the EU is about to have the Digital Services Act, which does include provisions to allow people to file internal complaints about content and to increase the transparency of content moderation. So Krisztian, from an industry perspective and from your perspective as an international antitrust attorney, does the Digital Markets Act and Digital Services Act framework adequately address the ability for platforms operating in the EU to remove harmful content without also hurting competition?
Maybe.
Oh, you want to go first, Anna?
Oh, and Anna, feel free to jump in as well. Well,
the Digital Service Act, the solution we found was to, in the EU jargon, we have some wording that probably doesn't make any sense for you, but it's without prejudice of. And it means basically, that without prejudice. So basically, the competition. First, the DMA is not competition to start with, but the obligations that companies have to comply with under the Digital Markets Act, economic regulation, should not prevent companies from fulfilling their duties under the Digital Services Act. Having said that, in terms of liability, there is no liability on companies in terms of content moderation. So the wording is also very cautious on the DSA. And the solution found was just to increase transparency so that everyone can control what are the terms and conditions of companies. How do they go about with harmful content, disinformation, and then to give an opportunity to the other side, to the end users who feel that their content is being moved in a I would not say in an illegal way, but in a unfair way, or that they can then seek for redress and find a solution. And it's a very tricky for policymakers. It's extremely difficult to find the balance because we cannot just ignore the problem, right? There is a problem there. At the same time, no one wants to change the liability exemption. So we think we believe we found a solution. We hope so, but it will, of course, we need to see on a case-by-case basis in the future how will companies as well implement this in practice.
And on that, I just wanted to follow up that, again, like regarding whether an abusive user content provider being moderated by a regulated platform constitutes material harm to competition really raises all these questions that I think, and concerns that I had mentioned before. We can be certain about those based on those terms that haven't even been defined. But it's, continuing with those concerns, it really shows that, I mentioned kind of like, the litigation in Texas and Florida as well, that really demonstrates in the U.S., there's little role for government in deciding what shows up in one's feed. And I think in that regard, it's very important kind of like to separate what are core competition principles and competition rules and what competition agencies and enforcement should be doing it, or what are kind of like, concepts that are outside of competition. Regarding the U.S.-EU comparison, I would point out that I think, U.S.-EU comparisons on content moderation can only go so far, because I think the European legal history and legal system perhaps is far more tolerant of the government playing a role in what content internet users can and cannot consume. And I think we see that as part of the discussions as well, with the DMA and DSA.
Thank you. Charlotte, did you have a response or? Oh, okay. Okay, so moving on. Both the U.S. and EU competition proposals also include data sharing provisions. For example, the Open App Markets Act calls for dominant app stores to give third-party developers access to development information, operating systems, and more. And the Digital Markets Act provides for data portability and interoperability with third-party software. So I'll make this another open question for the group. If legislation requires large platforms to open up access to personal data or operating systems, do these potential measures adequately account for privacy and security risk?
Let me take a first shot at that. Caitlin and I actually, along with a colleague at Brookings, after a number of prominent national security experts signed a letter that raised some questions about whether legislation would potentially threaten our national security and our cybersecurity. We held an off-the-record Brookings roundtable with a number of the signatories on that letter. Charlotte was participated in that as well, and we tried to drill down to talk about the security risks, both cybersecurity and national security risks, what the details were, and how those could be protected. Those legitimate public policy concerns could be protected. And what we found was that the national security experts really did not have a detailed point of view on the nature and extent of the risks and how the legislation would, at the end of the day, harm national security. The farthest they would go, and I believe some of them, again, all respected folks, were consultants to some of the tech platforms who would be covered by the legislation, was to urge that there be more hearings, that there be further study of the problem. But if these folks really had a legitimate concern, they ought to be able to tell us what it is and how it can be fixed. And when we didn't get that out of this off the record discussion, I came away wondering how real it was. And there was a column in the paper, in the Post, I believe, last week, talking about how on an issue like sideloading, Apple has made that available to members of Congress for years. That they have been able to do it, and presumably without running into the cybersecurity, national security risks that some of the opponents of this legislation are advancing. So I am not enough of an expert in this area to say there's zero risk here. However, we have found in other areas we've been able to legislate in a way that addresses those concerns. So given the lack of specificity of how much risk there is, I tend to devalue to some extent the legitimacy of those particular critiques of the legislation pending in both the House and the Senate.
That is such a great point, Bill, and I really appreciate that perspective. The only thing I would add is this legislation has gone through many rounds of amendments, markup in the House and in the Senate, and the privacy issue is one that has come up at every point, and that multiple times improvements have been made to accommodate folks with concerns about privacy. So I really think there are really strong privacy protections in the legislation now that are certainly give me comfort that our privacy is going to be protected in these new competition requirements. That doesn't mean that we don't still need a comprehensive federal privacy law. Excuse me, we absolutely do. And that would be a much more effective way of protecting everyone's privacy. So I'm still holding out hope that maybe Congress can get that done. But in terms of the new data sharing requirements in the legislation, I think really strong privacy protections have been put into the legislation. And I really appreciate that privacy advocates have come to the table and helped work out those improvements so that I think now the bill's in a really strong place.
Let me just add some concerns, kind of like if we actually focusing on specifics of what these potential concerns are with regard to data privacy and national security. You know, I think when it comes to kind of like these important areas, I really think that, you know, those concerns really can't be stressed enough. I think, you know, you mentioned, you know, national security officials, Bill. I think we've seen that a number of senators, you know, former top national security officials and other experts in this area have repeatedly voiced, you know, their serious issues and concerns, for example, about how AICO, and I will focus on that particular bill because this seems like the most advanced at this point, but how it would harm U.S. national security. And what are those actual risks? You know, I will mention three. You know, the bill forces then companies really to open their gates to really the Trojan horse of bad actors in a number of unfortunate ways. To start, there is the access mandate in AICOA. I believe it's section 3A4. It really could give potential bad actors the ability to use otherwise private APIs to access user data and then open Americans up to cyber attacks potentially. But then there's the data transfer mandate. I think it's section 3A7, which could give potential bad actors insights on how to avoid enforcement systems. And then third, there's the limitation on default services and settings in AICOA. I think it's section 3A8, which really could prevent companies from offering integrated automatic security features, which again would make Americans more vulnerable to attacks. Then, and very importantly, the bill doesn't contain adequate defenses or limitations that would allow companies to protect Americans. And companies can only limit access to bad actors that represent a so-called significant cybersecurity risk, which I think was an addition in the most recent iteration of the draft, which would really open the door to moderate or emerging cybersecurity risks. But what are those? It really could be exploited to harm Americans. And companies are really forced to go to court to determine when a risk is appropriate to block versus blocking all risks. But then there's also the rules of construction in the bill that in AICOA that only provides for an exceptionally narrow list of bad actors from the federal government. Those that I think appear on the list maintained by the federal government. And requiring covered platforms to wait for the threats to be identified and then added to a federal government list gives really bad actors further time and opportunity to continue to take advantage of covered companies' customers. And I have to say that, unfortunately, I think we all know that bad actors are much more sophisticated. All they need is to create an anonymous app, and AICOA will effectively require the covered company to provide access to them. But last and importantly, the affirmative defenses in the bill, they're unworkable, as they really don't provide a yardstick to measure how Americans could be protected using less discriminatory means. So in that regard, again, like the national security concerns with regard to AICOA are very much warranted.
So, Caitlin, should I say something as well from our side? I will be briefly, because I understand we are short on time, but we had this discussion as well a couple of months ago. And indeed, I mean, on the one hand, obviously, from a public sector perspective, the word security in this context is a big word, and China threats, it's a big word. At the same time, is a way too big, important issue to oversee. And in the provisions and obligations, the security and the integrity of the system of the companies was the only, let's say, the only reason that is listed as a possibility for companies to get out of some obligations, notably the side loading, for example. So yes, it's our view on this.
Okay, I don't know if my computer just froze, but thank you. Thank you so much. Oh, sorry. I can hear you now, but I think you might have froze a little bit, or maybe my computer froze. I'm not sure. Did I cut you off, or?
I don't know, Charlotte. Did you hear me?
Yes.
Yeah,
Okay.
we can hear you.
You did not cut her off. She was finished.
Yeah.
Oh, okay, great. Sorry about that. So I know we just have a couple more minutes, so I just want to ask one very, very quick question before we convene our panel today. Last month, EU-US leaders released a joint statement after the close of the Trade and Technology Council meeting, calling for a dialogue to find common ground and greater consistency on the US-EU approaches to competition in digital markets. So I just wanted to ask the group very quickly, do you think that this is a worthy goal? Are there any areas that are well suited for EU-US alignment on digital competition? Or alternatively, are there challenges that we might face in this area?
Can I start? First of all, I think you have to concede there are challenges, that we have different approaches, different enforcement mechanisms, US versus Europe versus UK versus other places around the world. There are going to be enormous challenges in terms of coordinating what the obligations are going to be. And I credit the platforms for raising legitimate concerns about how they're going to be able to comply with a bunch of regulatory obligations or legal obligations in different areas of the world when a lot of their traffic is international. So it's a challenge, and the dialogue that has been set up between the European Commission and the US government is an entirely appropriate way of trying to identify those concerns, hearing the concerns of the platforms themselves, parties who interact with the platforms. We have, and Krisztian's heavily involved in this in a prior life at the Federal Trade Commission, we have a great experience at working together bilaterally, the European Commission and the US, and multilaterally through the International Competition Network, through OECD, to try and identify areas where there are potential conflicts and try and get to a substantive approach that is as common as is possible, respecting the fact, of course, that there are differences in approach, differences in the legal system. So I think we've shown in the past that we can work together to identify problems. And I applaud the effort of Executive Vice President Beth Baer and Gina Raimondo and the US antitrust enforcement officials to actually have a process to make sure that the result of platform regulation doesn't create a biblical Tower of Babel where everybody's speaking a different language, but we're working together to try and get to a coordinated approach.
Caitlin, if I can have 2 sentences on that, just following up on what Bill said, and again, agreeing, with the key points of that, but we actually, CCIA and industry in that regard, we actually also offered some recommendations for the TCC last year, even, before the first TTC meeting. And we actually also submitted an additional set of recommendations, which I think is extremely important, which is on stakeholder engagement, which I think couldn't be underscored when it comes to kind of like the review, the study of these very important and complex, as Bill mentioned as well, often very complex digital issues. It's very important to kind of like get, like stakeholders' views in that regard as well. And in that regard, again, we view the TTC as a very important venue to engage on digital issues and really to further promote U.S.-EU dialogue and cooperation. As Bill mentioned, it goes back to, like a number of decades. And I think in that regard, we see it as a very important forum.
Maybe, I don't know if I can also say something. I of course, I agree. I see that in terms of the identification of what are the systemic problems, the bills are very much, and the DMA are very much targeting the same things. Whether they will eventually pass or not, it will change maybe the dimension of the problem of aligning. Because if ultimately the enforcement will be made, or the alignment will have to be made in the United States, either through the priority setting of the enforcement agencies or through the courts, due to the differences between our institutional systems, which probably makes the alignment a bit more challenging. But I think but I fully agree with what has been said, that it's not on the interest of anyone that there is regulatory divergence, because these are global players, and the less aligned we are, the worse it is, I think.
So in addition to regulatory divergence, I think we also should be aware of the possibility that the U.S. does not actually rise to meet this moment and does not put forward new platform rules at all. And in that case, Europe are the ones who are going to make this decision for us. So I really hope that in the U.S., policymakers are thinking about it this way and want to participate in the conversation. I think what we saw with GDPR, for example, the U.S. really was not leading on privacy, and now that is really the basis for all of the policy conversations that we're having today. I don't think we want to be in a similar situation of not participating in the conversation when it comes to competition. So I hope that U.S. policymakers will seize the moment and do something here.
I hope so too. And I think that these are all great points. I know that I would love to continue this conversation further, but unfortunately today we're out of time. Here at CSIS, we will continue to follow antitrust developments around the world. So please keep an eye out for additional events and publications. I know that I'll be closely watching for updates this summer on competition in digital markets, not only in the US and Europe, but all around the world. So thank you so much to our panelists. Thanks to Georgia Wood, and thanks to all of you for tuning in.
Thank you, Caitlin.
Thank you very much.